that legal realism continues to live as an active intellectual force, not simply as part of the atmosphere in law schools. And it's living in actually a much more radicalized form than it existed in before. So I think I've hit the limit of my time. I want to thank you for listening so patiently to what is a rather more academic discussion than I think people ought to have inflicted on them at a political gathering. Thank you.
George and Bruce have both volunteered for a question and answer period now. So if Bruce's subject was a bit too academic for you, maybe you can fire some questions at him that would get him down to some of the practical issues involved. So I'm sure he'll entertain those as well. Mike.
Yes, Mr. Shortt, I enjoyed your presentation immensely, although it's probably the most depressing thing I've heard in a long time. It gives me very little hope that the kind of actions that Meeks involved himself in, and other libertarians who look to the courts as a possible break or possible vehicle to recognize individual liberties or at least prevent transgressions. And what you're saying essentially is this view that somehow judges or courts can do whatever they want and it tends to be whatever the government wants, apparently, is just not going to be a very fruitful avenue for people who are concerned about pervasive statism and statist solutions and constantly encroaching government action. And so my question is there any rays of hope or any kind of legal theories on the horizon or counter actions to this legal realism? And it's apparently its great-grandson, Marxist law professor, which is really the most chilling news I've heard in a good while.
One of the luxuries of giving a 20-minute talk is that you get to make all kinds of irresponsible generalizations. And I think the general burden of the message that I was trying to convey is that, no, I wouldn't pin my hopes on the legal system. Obviously, the members of the bar are not all of one mind, and the members of the judiciary are not all of one mind. But it's amazing what you tend to pick up in school. School really furnishes your mind. And if you're not terribly intellectually inclined, and most lawyers and judges really aren't in a serious academic sense, you tend to find that people of that sort go through school, that is their intellectual academic period in their lives, and then they get on about the practical work of their lives. And what they learn during that period provides the conceptual and intellectual framework that they draw upon for doing whatever they're going to do. Now, there are judges out there who are sympathetic. There are law professors. Richard Epstein, for example, at the University of Chicago, has done some excellent work on the importance of rights to our legal system and the relationship of the system of natural rights to preserving our freedom. But for every Epstein, you've probably got 5 or 6 people in the critical legal studies group, and you've got 100, for want of a better term, sort of New Dealers. You've got people, that is, who grew up in the law with this New Deal conception of what the legal profession and the judiciary ought to be doing and is entitled to do. Now, one other thing that you said that I think I ought to comment on is simply that I believe you said that the judge is going to do what they want to do, and what they want to do will be what the government wants them to do. That's really not the case. The profession likes autonomous power, and that's one of the siren songs, as it were, of legal realism. It legitimizes in the mind of the judge and the lawyers appearing before him, that they are somehow entitled to do what they're doing. But they are well, obviously the judiciary is an independent branch of government, and what it does is essentially expand its powers beyond all reason. So I suppose my message is somewhat pessimistic. I wouldn't look to the judiciary to fight this battle, I guess is what I'm saying. There may come a time when there will be another sea change in legal thinking, but it's a tremendous uphill battle. If you look at the present Supreme Court, I think that you'll find that almost all of them would, no, I think I'll be bolder. I'll be even more responsible. I'll say all of them would flatly reject any notion of natural rights. Certainly would not view their job as interpreting the Constitution in a way that most of the framers would have understood it to be meant to operate. So, again, I think the battle's going to be won or lost elsewhere. Lawyers tend to be a lagging indicator, I think, of where society is. And when you see lawyers, judges, and law schools changing, then I think you'll be in a position to say that you've really made some progress.
Any questions? Harvard and any other the law schools offer courses in natural rights? Because you guys only have your PhD from Stanford and Boston. I guess that's where you got your theory of natural rights from. Did you also have exposure to it at Harvard?
Your first question, the answer is no. The law school curriculum does include, well, I'll tell you, Harvard's a very interesting example because it is the one faculty where the crits, as they're called, have captured the place. You can't make a faculty appointment at Harvard that the crits don't like. And a number of very, very good conservative legal scholars have been prevented from joining the faculty. These were primarily people who were involved in what's known as the Law and Economics School of legal thought. There are no courses on natural rights taught at Stanford. Actually, I suppose my introduction to, well, not my introduction, but certainly the most formative phase of my thinking in this area took place in Scotland, reading Hayek, and later, I suppose, my thoughts became a little more crystallized through talking to Murray Rothbard. But I think academia at this point offers relatively little to anyone who is seriously interested in the subjects that you raised.
Question for both of you, Mr. Meeks. We appreciate the extent to which you went to gain notoriety to get us enough votes to say anything else. Is there an easier way? And I'll follow up with a question for Shortt. There's a Libertarian supposedly nominated to the 8th Circuit Court of Appeals out of California. Is that the 8th Circuit?
Nine.
Nine. Yeah, sorry. I don't recall his name. Do you know anything about him? Have you heard of
Oh, yeah, sure. But go ahead.
I'm not sure whether there's an easier way or not. An all-expense-paid vacation for a year does give you some time to prepare yourself for a campaign and get your thoughts ready. Realistically, though, yes, there obviously is an easier way, and I think we have found it and are finding it now when we're attracting candidates that have national stature and when we have people looking seriously at the party as having answers, which we're beginning to do. Teresa and I noticed in our campaigning around the state that at least in Texas, for the first time, the news media was taking us seriously and was asking us questions like, how would you handle such and such a problem, or what is your view on so and so, rather than the older approach of, you're not serious about that, are you? So I think, yes, there is an easier way, and I think we're beginning to find it now.
Yes, I am familiar with Bernard Segan. He wrote a book on the Constitution and economic rights, one among many. But that's the book that I think is probably the most radical from the standpoint of today's legal profession. And in that book, he essentially points out that contrary to what's taught in law schools, contrary to what Oliver Wendell Holmes at one point said, the Constitution does enshrine a particular system of political economy. And it's one which is based on property rights of a particular kind. And judges aren't deciding cases properly. The Supreme Court is not doing its job unless it operates consistently with those principles. So anyhow, he is an excellent choice, and I would only say that you have to bear in mind that he is one of, and I don't know how many are sitting on the Ninth Circuit. We keep increasing the number of judges these days, but he'll be one judge out of about 12 or 13 or 14 on that circuit these days, and one out of about 600 federal judges. So, that's one for us and 600 for them. But let me just go back to a point that was made earlier. I guess what I was trying to say in response to an earlier question is that the changes that need to be made are going to come about through the efforts of people like Mr. Meeks, people like you. If you're looking to judges and lawyers to protect your rights in the sense in which we all understand that term here today, they're not going to do it. The first thing they're going to do is deny that you have any such rights. Second of all, they're going to think or tell you, if they're a little tactless, that they think you're terribly unsophisticated for thinking that you have such things. And the reason they're going to think that is because, well, when they went to law school, it was thought unsophisticated and uncouth to say such things. So obviously you not having been to law school and gotten that bit of wisdom must be unsophisticated. So, it's just a problem. It's a broad cultural problem, as it were, within the profession, and it's very difficult to talk to lawyers and judges about such things. Not to mention the fact that the view that we espouse is one that essentially works against their professional interests and certainly works against any sense of ego, because after all, the more limited your role, the more unimportant you are. Who wants to be unimportant? Not a judge.
Yeah. Address both gentlemen. Have either of you noticed any difference in the adherence to any concept of either natural or constitutional rights between elected or appointed judges?
Haven't had a whole lot of opportunity to observe, but from what little I have, basically no.
I haven't a clue. I mean, it's such a difficult question. The effect of the two systems, the relative merits of the two systems of choosing judges is one that's very complicated, and I really have no idea whether you're going to, on balance, to use a phrase that I just mentioned before, come up with a better judiciary if you handle it through appointment, or whether you as compared with handling it through election. I mean, it's a very messy empirical kind of question, and I have no idea how to answer that.
I've been trying to find out what is the formula for a grand jury hearing on income tax. Can you, Mr. Shortt, elaborate on that? If we as a group wanted to do that, what's the formula for getting that done?
I'm not sure what you mean by a grand jury hearing on income tax. Grand juries are impaneled for a time period, not for a particular purpose, and someone must bring to the attention of the grand jury a case. In fact, what is normally done is a grand jury sits there and takes whatever the prosecutor, the U.S. attorney on the federal grand jury or the district attorney on the local, feeds them. Theoretically, although it very seldom is done, citizens can go to a grand jury and take to them whatever concerns they have. I assume that that's what you're talking about. We can tell you from the San Antonio experience that getting to the grand jury as a citizen is a very complex matter. The meetings of the grand jury are public record and open to anyone, but when you try to find out, you run into stonewalling. The theory doesn't hold. You don't find out. The only thing that works, apparently, that has worked in San Antonio anyway, is perseverance. You just have to keep harassing them. When is the grand jury going to meet? I want to go talk to them, and keep on. And eventually they will back off and let you in.
I really don't think I have anything to add to that. I am, in fact, I'll tell you, actually, you'd probably be better represented in connection with a grand jury hearing by Mr. Meeks than by me, since I tend to do financings and mergers and acquisitions. I think I've been in a courtroom all of twice in my career. So.
One last question. Mike, okay, go ahead. Yes, Mr. Shortt, you did allude to the law and economics school, which is, I guess, one of these newer trends in legal theory. And I heard David Freeman speak about this in California. Do you think that this approach, which apparently is very libertarian, at least I thought so in the explanation, do you think this might possibly prove to be a future inroad in terms of this philosophical approach to law that might counteract some of the other tendencies right now?
It is certainly the main challenger to the received orthodoxy of the legal realist school of thought. But I think you have to realize that any libertarian implications of the Chicago approach to analyzing legal problems are somewhat a byproduct. I mean, fundamentally, the law and economics school is informed by a kind of utilitarianism. And it just happens that if you take an intelligent point of view with respect to economics, that is, if you try to frame your decisions so that you're going to be maximizing society's wealth, which is essentially the way in which people like Judge Posner would decide a case, then you're going to be much more attentive to property rights of some kind. You're going to be much more protective of business, I think, than your typical liberal judge, I suppose. But the object, from their point of view, is not to preserve and protect natural rights. It may happen it may happen from time to time as a byproduct, but it is certainly not the primary objective. It has certainly thrown, I guess, some sand into the gears of the people who would continue deciding cases as they have in the last 30 years, simply because it represents an intellectual challenge to what they've been doing. But it's certainly not the solution. And in fact, Professor Epstein and Professor Segan, certainly Professor Epstein is very much in opposition, viewed as very much in opposition to the law and economics analysis. You see, let me just give you one more word on that. You see, under that approach, what rights you have will depend on what they view as being economically efficient. So your property may be here today and gone tomorrow, depending on views of economic efficiency.
I did neglect to mention there is on the tables that you will find a little pamphlet on the nature of constitutional government that I wrote some time back. You might want to take those up with you.
Okay, thank both of you very much for being able to join us this morning. Next